collaborator. But here is the real question. If AI helps create something valuable, who actually owns it? And even more importantly, how do you protect your ideas in a world where technology can replicate them in seconds? Because today's digital economy, protecting ideas is just as important as creating them. To guide us through this important conversation, we are joined by experts from Talwar Associates and TT Consultants. They help companies across industries protect their ideas, manage IP portfolios, and leverage AI-driven tools to strengthen innovation strategies. Let me now introduce our distinguished speakers for this session. Mr. Jitin Talwar, he is the founder of TT Consultants, XLSCOUT and Talwar Associates. I hope I pronounced that fine. And he has been at the forefront of transforming how organizations use AI to manage and protect intellectual property. He has also served as the past president of TiE Chandigarh, playing a key role in strengthening the startup ecosystem. Please join me in welcoming Mr. Jitin Talwar. Our next speaker for today is Ms. Pritika Kohli, an associate partner at Talwar Advocates. She specializes in intellectual property and corporate law, advising businesses and innovators on how to protect, manage, and maximize the value of their intellectual assets. Her expertise lies in helping organizations navigate the complex world of IP strategy, legal protection, and innovation management. Please welcome Ms. Pritika Kohli with a huge round of applause. Okay, then I would request sir to kindly start the...
Thanks. I can be there because I need to move the slides. Hello. What's your name? Thanks, Sukhmani. Thank you. Just a small correction. I have served as the president also. Not just as a past president. No, that's okay. I appreciate that. Okay. So we are going to be talking a lot about, AI, different models, and the legal aspects around that. One of the reasons we kept this as a master class was that increasingly companies and individuals are getting into legal hassles, leveraging small applications, etc. And without adequate knowledge of how and what goes into it, what's behind it. The matter gets serious when these models or the content that is derived from these models gets into public domain and it becomes bigger. So we wanted to make sure that not just for folks who are out here, but as we record these sessions, create more content around it, we get information out there and ensure that people are leveraging this wonderful technology which is everywhere to the best of their ability and legally. So generative AI, we all talk about the technology around it. Okay. So this is also important as you are adapting different models that could be best suited for your business, especially if you're working with customers and contractually you're bound by these models. I've heard so much about customers adapting or people adapting a Chinese model or a model that is coming out from China, for example, a DeepSeek, and then providing that into an enterprise, kind of a use case, and having to be to answer questions that come around from there. So understanding legacy, questions around legality of what is to be adapted, and understanding the legal aspects about different AI models is important. So let's jump right in. What you can see is, first, like when we look at a AI model, you look at it from 3 or 4 different perspectives. The first is how you are accessing the model, right? I think this is something that most of you in your business would have seen, right? Now, by now, this is so important. So you can access an AI model pretty much through a platform, right? Through an Azure, OpenAI, AWS, Google, Nvidia. You can access it through a platform, kind of like download the model sometimes, which is open weight or whatever. Or you can do a web access, chatgpt.com, etc. I don't need to tell you. Or you can do an API access, right? Most of these are pretty much straightforward. Or you can do an open model, like go to a Hugging Face, etc. Or very less, but it also happens, you can access it on host it on a GPU infrastructure, etc. Right? This is the technical part of it. Why it is important is how the contracts that are underlying each of them are very different. For example, if you are doing an API access, and you are doing an API access on, for example, a Claude or a Gemini, API access on an OpenAI or a Claude or whatever, DeepSeek, the indemnification clauses are built in. The data usage for that data to be leveraged by that platform are also built in. They are important because then you pass on, if you're building on top of that, building applications on top of that, that you pass on those indemnifications, etc., to your customer. So it's important. The second is how it is trained, right? So again, as you might know, generative AI models are trained differently. Legally, why this is important is, for example, if it's a reinforcement learning by human feedback kind of a training, then the data of those reinforcement learning is supposedly owned by either the platform or the folks who are providing you the training. If it's a mixture of experts, for example, the Mistral was one of the most important example of Mistral of experts. That is also how the AI is trained. The most relevant example in this, in how the training happens, has been the example of Anthropic. What they did at one point was they picked up novels from all over the place, and they started training it. They had to eventually pay $2 billion. The case is still ongoing. So how the training happens, and then how it is leveraged, and if your platform or your application gets too big, then there are problems, legal issues that you have to indemnify your customer or whoever you're building your application for. Then comes distillation. What happens in distillation typically is, a model is picked up, it is basically kind of like worked up along with another model, and they call it distillation. I don't know completely technically how it works, but typically what it means is basically they're distilling one model with some other expert, etc., and then things happen and it works upon it, right? What is the next one, especially in the area of drones and physical areas, multi-model, when they are spatially also aware, they're aware of images, they're aware of videos, these models, and then again there are licensing aspects that come in. If you're building applications which are big, applications which are relevant, applications which are commercially running into hundreds of millions of dollars or multi-million dollars, how the model that you're picking up is trained is a very important aspect of how you're passing on your application's indemnification to your customer, right? So that becomes important. Then is the third one. Now we are getting into a little bit more technical importance, is especially in terms of geopolitics. What is happening is that countries are becoming more aware that this is these next 10, 12 years, at least 2 to 4 years now, next coming up, are going to be free for all in geopolitics. ठीक है? तो कल को अगर कोई president of one country decides कि यार मुझे ये वाला देश पसंद नहीं है, तो इसकी सारी AI काट दो, इसका बिजली पानी तो काटो ही काटो, पर इसका तेल भी काट दो और साथ में AI भी काट दो। मैं जान के हिंदी में बोल रहा हूँ ताकि लोगों को पता ना चले वॉशिंगटन DC में मैं क्या हूँ। तो कल को अगर किसी को प्राइम प्रेसिडेंट को ये लगा कि यार मुझे इस देश की शक्ल पसंद नहीं है, आई वांट टू स्टैंड इट बैक टू वेयरएवर दे बिलोंग टू, तो हम इनका सब कुछ बंद कर देते हैं, ठीक है? सो कंट्रीज, कंपनीज आर गेटिंग अवेयर अबाउट इट, एंड व्हाट वी आर सीइंग इज a movement towards sovereignty of models. Now sovereignty of models कैसे आएगा आप अपने बिजनेस में भी देखेंगे. It will come through open source, okay? That you don't rely upon APIs or direct access. You pick up open source models and train those models on your own. Small language models are going to be becoming more and more important. So there are two types of open source broadly. एक होता है open weight, but the code is also open. The other is open, the weights are public but the code is not disclosed. And then of course the closed source models. So we've listed the three of them. First is open source, open weight, code is public. So some examples are given. Then the other one is an open weight but the code is not disclosed. Okay? So ये Llama 4, DeepSeek, Quen. So this second part is the one which is the most popular now. Because आप खुद ही देख रहे होगे Quen, Llama, DeepSeek, Mistral, आप इनको ले रहे हो. Increasingly companies are wanting to build applications on them, not just on closed source, right? So if you have to learn a skill in this era, pick up an open source model, try to build applications on this. Legal risks around leveraging open weight models, closed data models are higher because you are responsible. Because again, you are also looking at taking up a Chinese or some model, and then you are responsible if there is a vulnerability. Okay? So what platform you take up an open weight closed open source model is something you've got to be mindful of and careful about. Then this is where legal testing comes in. Okay? आप जब एक कोई मॉडल के साथ काम कर रहे हो, जो रिस्पॉन्सिबिलिटी है, लीगल रिस्पॉन्सिबिलिटी रिलेटेड टू डेटा हैंडलिंग, अगर कोई उसके पीछे vulnerability है, for example some form of a data goes back to a Chinese or a American government or something, you're liable. Confidentiality, privacy, bias, hallucination, कहीं पे hallucinate करके डेटा को गलत कर दिया, किसी कोर्ट के केस में कोई प्रॉब्लम आ गई, the responsibility squarely lies on the application provider, unless that application provider decides to pass it on. Indemnification in terms of copyright, जो ट्रेनिंग डेटा सेट यूज किया है, अगर आप ओपन सोर्स उठा रहे हैं तो that indemnification belongs to you. Output ownership and modification and control. Typically when you pick up an open source model and build something which is an application on top of it, चाहे उसको आप fine tune करते हैं, train करते हैं, etc., वो liability that belongs to you or your company depending upon who's building it. So these are very important aspects when you're building applications, when you're building contracts that relate to applications. Those aspects have to be put into the contracts and created. अब आप वो contract भी ChatGPT से बनवा लो तो बनवा लो, but most of the times those would not be sufficiently capturing all of that and taking this form.
Is that okay if I ask a question?
We have a set of questions after that, but you can sure. Let's keep it interactive. No problem.
Just to understand the third point which is raised in hallucination, to understand it better, are you trying to say that, for example, if we ask something to ChatGPT and it gives us the wrong data,
that means the responsibility of giving us that wrong data is on ChatGPT and we can sue them? I'm just trying to understand it.
So when we are talking about this aspect, we are talking about an area where we are talking about when you are building an application leveraging a model.
I get it.
And yeah.
I get so
but when it comes to ChatGPT, you're using it. You're also accepting the terms of service of ChatGPT, and those provide for just exceptions, representation and warranties, where they don't hold themselves liable if there is a even if you're paying for it, they are not. You can't sue them for that.
so then we can also build such clauses in our legal contracts when we are doing this.
Absolutely.
That's what I wanted to understand.
That's the crux of the point. You
Thank
build
you.
in. If you do not build in like the way they built in it, then the liability squarely comes on you.
that's what I want.
More importantly, look at the second point and the first point. You pick up a model. आपको कोई client, आपका कोई defense का client है या आपका कोई client है जो या आपका कोई मतलब vendor आप किसी के लिए काम कर रहे हैं और वो sensitive data है. आपने open source model uठाया, आपने कहा ये तो end to end मैंने बनाया है, and the liability comes upon you, है ना? So there was we all know about this famous university issue that happened. Hardware किसी और का, software अपना और उसको कर दिया, right? So if you pick up a model, ensure that that model has you've got to kick the tires in terms of that model and work it out, especially if you are working in a enterprise B2B AI domain. Okay. At a small level, these challenges do not matter, but when you are working in a systematic way, etc., these things matter. I'll give you another example. ये practically हुआ था. Actually ये practically शायद नहीं हुआ, but actually नहीं हुआ था. So, but there would be systematically cases where somebody might have built a model on top of like an AI model, and if some hostilities broke out, the AI model that it was built upon would be mapped by the other parties, and those buttons can be systematically switched off. Right now, that's why the government of India has now recently issued these notices that CCTVs of particular providers should not be leveraged because switching off, switching on of hardware, the software that is overlying it is very easy. So if you are building a important infrastructural element, आप सिर्फ अंधाधुंध उठाकर कोई भी मॉडल उठाकर आप नहीं बना सकते हो, उसको आपको इंश्योर करना पड़ेगा. That's your liability, right? So that diligence has to be done before we are adapting a particular AI model. Now, especially when it comes to Gen AI models, as a legal question, when you apply any AI model, it has to be looked at operational, or whether it is functional, whether it is strategic, or it's a product or service. आपका जो question था उसके अंदर वो प्रोडक्ट और सर्विस के अंदर था, लेकिन कई बार वो स्ट्रेटेजिक भी होते हैं, कई बार वो फंक्शनल भी होते हैं, कई बार वो ऑपरेशनल भी होते हैं. सो द कॉन्ट्रैक्चुअल एस्पेक्ट्स, कंट्रोल्स दैट गो इनटू leveraging AI models for each of these deployments is different. Now we are also talking about agentic, where the human the agents are talking to each other, so the human control is less and less. और कल को वो क्रैश हो गया, कोई कार के अंदर क्रैश हो गया, that liability will increasingly be the service provider's liability. You cannot accept it. It cannot be accepted, right? So those exceptions don't lie as autonomous and autonomy of AI models increases. So the service provider's liability while adapting all these models is increasingly high from a legal standpoint. So आपको क्या क्या देखना है? पहला, right to use, कि यार ये internalize करना होता है when you are like working on AI adaptation. क्या आपके पास उस चीज़ का राइट टू यूज़ है? क्या उसके लाइसेंसेस वो हैं, ओपन सोर्स है? ठीक है, ओपन सोर्स डज नॉट मीन इट इज़ फ्री. ओपन सोर्स मीन्स आपके पास एक लिमिटेड अडैप्शन फ्रेमवर्क होता है. सेकेंडली, वो AI कैसे काम कर रही है, उसका ओपन सोर्स है, कोड ओपन है कि वेट्स ओपन है, आप उसमें कितनी चेंजेस कर सकते हो, क्या आपके लाइसेंस टर्म्स है, सेफगार्ड्स क्या हैं, उसके पास IP लाइसेंसेस है कि नहीं है, और डेटा प्रोटेक्शन लॉज को वो कंप्लाई करता है या नहीं है, राइट? इन चीज़ों को यू हैव टू बी केयरफुल बिफोर यू अडैप्ट. टिपिकली दीज आर ऑल इंटरनलाइज्ड, सम लीगल डिपार्टमेंट शुड बी लुकिंग एट, बट बहुत बार ऐसा होता है कि आप गूगल सर्च करके देख लेते हैं, एंड इवेंचुअली दोज इश्यूज कैन कम इन और कैन क्रीप इन व्हेन यू आर अडैप्टिंग. Up the advantage in a closed source environment, the advantage is these issues are pre-done by the service provider. तो कई बार ये indemnification भी provide करते हैं. So अगर आप एक base level की applications बना रहे हो, तो the basic diligence in closed source is done. Whereas जब आप open source बना रहे हैं, then those basic like diligence has to be done at your end, and it is our experience and it is our like we've seen that most of your open source models will be the ones that will be leveraged increasingly as we move forward. I'll give you an example on where this is. China, we all know. We know China is technologically little ahead of us, a few years perhaps. What we have seen is most of the adaptations of applications in China are typically happening in the open source space. उसके दो रीजन थे. मजबूरी का नाम महात्मा गांधी. उनके पास GPU एक्सेस नहीं थे, उन्होंने लो कंप्यूट एनवायरनमेंट्स में जो चीज़ें बना सकते थे उन्होंने बना दी. They don't want to rely upon these big global forces, right? So they also leveraged it. So the advantage with open source is it's inspectable, can fine tune, free plus infra. This is very important, and you have full control, but with full control also comes full responsibility. So broadly, when you're looking at open source models, please be reminded that open source does not mean free. There are for example, these ones like GPL license, AGPL license. How many of you have seen, are using or leveraging open source? Let's have a show of hands. Open source, anybody? आपने open source में कोई license देखे हैं? क्या आपको लगता है open source free है?
This is one area after today's talk. I think I would have.
So typically open source में Apache और MIT license होता है, which is generally tending towards free to use. Whereas अगर GPL, AGPL है, तो this is sometimes worse than closed source, right? So you have to look at it, create the guardrails and work through it. But again, especially if you are working in the enterprise, when you are working on B2B applications, when you are working on responsible AI adoption, when you are working on brass tacks AI adoption, तो आपको ये even in open source you have to look at what kind of models you can pick up. How many of you are aware of dual use technologies? Anybody? Dual use technologies. Let's give you an example. एक drone है, okay? What all can it be used for? Let's talk about it.
Inspection.
Inspection. That's called dual use. That's called dual use, right? So a lot of applications that are being developed in AI are dual use technologies, right? Right now it's an evolving technology. अभी वो पूरी तरह हुआ नहीं. So even when you are adapting a closed source technology, you have to look at what kind of license that is being there. Sometimes they don't allow you for using for sensitive customers, etc., right? Increasingly, as these technologies become more pervasive, they become more available, they become more contentious, you will see that companies will start looking at more and more of these licenses, right? For example, when you take a closed source license in a permissive environment, in an environment where they have given you use, you can't start using it for an defense application. You can't start using it for a sensitive application, right? So you have to look at the full service level agreements. You have to look at indemnifications. You've got to look at the data, especially when it comes to Anthropic. We are all aware. How many of you are aware of this Anthropic versus Department of Defense or Department of War issue that happened recently in the US? Anybody? क्या हुआ था बताइए कुछ थोड़ा सा.
So the department was wanting for mass surveillance. They are wanting mass surveillance to Anthropic models to the US citizen, but Anthropic has denied that they will not use these models for mass surveillance and destructive weapons.
So that's what we know. Okay, that's what we know. However, you can never be sure about what was the real issue behind it, right? The point is, आप जब किसी third party का compute use कर रहे हो, किसी third party का data use कर रहे हो, किसी third party का application API use कर रहे हो, उसके जो service, उसके जो terms of use हैं, आपको वो application में देखने पड़ेंगे. आप वो उठाकर आपने उसको मतलब किसी अपने client को दे दिया, तो that is not the best way to go about it. You have to see whether the terms of use as you grow bigger, they will start saying ये तो आप use नहीं कर सकते, ये तो हमारे terms के against है. Then comes denial of service. Then comes indemnification that you are liable to. So you work with your AI provider and look at the terms of service and look into it in more greater detail and see. So especially when it comes to defense, cyber security, drone leveraging, autonomous vehicles, you've got to be very, very careful. The liability, the buck stops with you, your company, you're liable. You cannot say मैंने तो दिया था ओपन एआई ने मना कर दिया, ऐसे नहीं कर सकते. You had a question? Did you have a question? सूत्र? नहीं. That's okay. अच्छा. The third one is also very important here, where the AI models will increasingly be on the edge, which means the device के अंदर AI model embedded होगा. तब आपका control और कम हो जाएगा, but आपकी liability और आपकी responsibility, criminal liability और responsibility बढ़ जाएगी. It's not just civil liability but criminal liability. कल को किसी ने किसी के घर पे गिर गया, कुछ issue हो गया, the liability remains yours. For example, if a drone is flying on its own, there is some agentic application that is running it and that goes south, the liability becomes yours. It is not the device owner's liability, it is not the liabilities for the developer's liability. Okay. With that, generally we talk about what are open source licenses, what are closed source licenses, what are permissive licenses within open source, which of these licenses come in. So for a lot of them, I'll bring in Pritika to explain and take forward the licenses, the legal aspects of that, and the law around adapting these licenses in a human / copyright / streaming kind of a way. Okay, so
thank you, sir. So I think we've got a deeper understanding on what are the types of licenses and what is a closed source and an open source license. So just building on that and what Sir rightly said, that very important are the contractual aspects. What is the indemnification liability? And I'm going to show you a couple of clauses that all these open source and closed source applications have. And we often say, I agree, and just download. We do not see. On a lot of your applications, we just say, I agree, because we want to use the application without reading certain clauses. And I'm just going to highlight a couple of clauses which I think, before saying I agree, let's just have this practice from today to at least go through them before agreeing to it. So just starting with a few examples of open source licenses, like how Tesla is using an extensive open source license source software in automotive driving. We all know how Tesla is developing its automotive industry, and while adhering to automotive safety compliances. So these are certain licenses that it uses, which is GPL 3.0 and LGPL 3.0, pioneering and promoting open source development in the automotive industry. So a lot of industries, almost all industries, are influenced by all these platforms. So is Netflix. It adopts a combination of strategies and licenses, like it uses the MIT license, and a lot of internal processes of Netflix are based on open source licenses. Coming to closed source. Closed source, Apple and Microsoft are great examples on how they use closed source licenses. And actually, because when we use an Apple phone, we all say it's a very safe environment rather than an Android. Like a lot of people say that. So why so? Because they are using a lot of reliant and closed source models to actually develop their software. There are certain licenses. There are commercial license, there's a non-commercial license, and there are proprietary licenses that are involved in closed source. Your commercial license, it contains open source terms, and often they are, there's a money component involved in commercial license. You pay a certain sum to use the closed source license, or an open source for that matter. Non-commercial and forbidden right to use license, it prohibits a software for commercial purpose. I can use the closed source or an open source if I make a payment, but I cannot commercialize or whatever I build on that platform. So that is your non-commercial use. Your proprietary license is what you hand out by the IP owner. So this is very important, because whatever you build on these sources, whether it's an open source or a closed source, who is going to be the IP owner? So that is very important. If whatever I'm building on these platforms, if I'm leveraging it and giving it to somebody else to become an IP owner, am I giving that or not, is a proprietary license that I'm supposed to give. So there are certain illustrative licensing terms on the screen, which you often see when you click on I agree. What one can do, what is the modification scope of each source that we are using. That is again very important. Can you copy it? Can you lease it? Can you sell it? So these are the terms which is very important when we are using any such open source or a closed source. What will happen about the output that is created for your business? Can you share it with your customers, or you cannot share it with your customers? Is it proprietary to you? And what are the liabilities that will fall on you? That is again the second aspect that is important. And all of these terms are available if you use an OpenAI. Similarly, if you use Llama Meta, these are certain terms that will reflect on your screen. You know, what is the grant of rights? Whether it's is it non-exclusive, is it exclusive? So Llama is non-exclusive. You can build on that particular platform. Can you redistribute it? Because why these clauses are important? If you cannot redistribute, and if we have not read the terms, and we do not legally abide by it, you may get stuck in a lawsuit. So therefore, it's important what is the use of an open source and a closed source when we are signing for any license. Does it obligate you to put what kind of inputs and outputs that have to be there? What is the disclaimer of warranty? So that is the output which is provided on an as-is basis. So the output that has been given to you is as-is basis. This is what the closed source has given to you. Now it's my responsibility. That's what Llama says. Similarly, Mistral, the prompt ownership, who will be the owner, the output ownership, output similarity, and output accuracy. So these are certain terms that I wanted to just list out, which is very important when we sign up for any of these licenses. Diligence, so when you develop a business, it is you develop using an AI product, an AI platform. And what you must ensure, I've just highlighted some of the points. One is that your IP is secured. Second, that your third-party software and content is fully licensed. Third is how your data is trained. Fourth, very, very important, and especially now in India due to the data privacy laws that have come, which is your IT and data protection laws. And last is security from your deepfakes and any discriminatory content. And how are you going to ensure it for your work or your business or service, whatever you provide, is through contracts, policies, and securing your IP. So before even you go and leverage such license, whatever you have made till now, you need to have protection over it, either through a patent or a copyright, whatever. If you're in goods, then maybe trademark. So the IP protection is very important before putting anything out there on any such platforms. So these are certain key considerations that we need to have in place. I'm just going to reiterate a few, which is if it is free or paid, if it's commercial or non-commercial, whether modifications are allowed, whether you have to pay any royalties to it, what are the copyright liabilities, ownership of the output, who will be the owner at the end of the day, indemnity if it's there, to what extent is the indemnity. Now coming to the fact of when I was talking about IP, it brings me to this topic of having patents. When in today's time we're all using AI to build our product or service or any platform. Now how do I protect it? Can I do a patent registration for the same? So this is a very important question, and the same has obviously gone to the government as well. Because our Patent Act especially says that computer programs per se are not patentable, which is that your algorithms cannot be patented. So what do we do about it? So the parliament, when it went to the parliament committee, and I want to say it out here and to have clarity in that aspect, that if there is a computer program or algorithm, if we put it to a technical effect, because the government that time say that the word per se is written, but today, if I have an algorithm or a computer program and I put it to a technical effect or a hardware, if I can prove that in the claims of my patent, I can get a patent. So this is the way, when you rightly approach your patent agents or the law firm that you're working with, you need to make sure that your claim, so that your patent goes through, because a patent is an expensive process. So To make sure that happens, we need your computer program has to be affixed to a hardware. You have to show that it has a technical effect. Once you're able to prove that, you can easily get a patent. So just sharing the statistics here. So the NASSCOM report said that 50% of patents which are filed during the 2015 to 2021 were all related to AI. And it has doubled since then, and patent controllers are seeing about 20% growth in patent applications which have AI applications. So it's happening. It's not that it cannot happen, it just needs to be interpreted in the right way. So patentability of AI generated inventions, who can file for an invention? Now if I'm using an AI, can I file for an invention? That question again comes, what is going to be my output? So if the act clearly says, what our law says is that it has to be a human involved. Once there's a human involved, you can file for a patent. So whatever the output you're generating using an AI, you have to have a human intervention in that. So once that happens, the government allows you to file for a patent. Because the human has to be named as an inventor. So that's how it goes. And when we talk about copyright, there was a copyright that was granted, which was Surya's, by the Indian copyright, and it was generated through an AI tool called Raghav. It is an interesting case. But later, it obviously got withdrawn because there was no human intervention in it. So the law is still developing on that fact, but the invention and progress still continues to be there. Protecting your IP, so the few points on copyrights that I want to takeaways on the authorship is that if AI is the software itself, so copyright allows protection. So even if you cannot get a patent, let's come to copyright. So your copyright will allow inventions to be copyrighted if you have algorithms in place. So you can go and you can file because software programs can be copyrighted. So there are various IPs involved, and that is why this is important. Sorry. Yeah. So the expression is protected, not the idea. I have an idea today that I want to invent something, that is not protected. When it comes to the actual form, whether it's a software form or a product or a service, anything, that can be protected. AI generated content, AI cannot be the owner of an IP that I exactly said, and the law is still evolving on this particular factor because in the coming days this is going to happen. So the law needs to come on this fact, and this is something to deliberate on. These are certain questions that are raised in the advent of AI and creativity, that who owns the output, and I think I've addressed these couple of questions. It has to be based on a human intervention, then of course you can go. And if they are pre-existing copyrighted work, now comes the fact that if there's something pre-existing and I'm making a derivative of that using an AI, can that be protected? So to that effect, the key questions is unauthorized use, ownership, attribution, and remuneration. If I'm using a derivative of any work, I must take permissions, and then the set can be protected under the IP laws. Because of course there are multiple stakeholders in the set process. Coming to something interesting, and I'm sure everybody is aware of it, personality rights. Now what is that? In a personality right, we all recognize a lot of actors by their names or by their, the way they act, the certain words they speak, and popular dialogues of the actors. Now what is happening with them? With them as well, when AI is interfered, and I'm going to show you some examples wherein their voice have been used at certain platforms without their permission or knowledge. So these are the aspects, and we have provisions for that, and there have been cases, and I'm just going to illustrate a few of them to you. So like Amitabh Bachchan filed for protection of personality rights in India because of his voice and mannerism and the names that were granted protection. So we all can recognize his voice, and you must have seen that a lot of phone calls that come either through some call centers, you might say that, oh, they are actually copying his voice. So actually the court in the Delhi High Court granted protection to Amitabh Bachchan in that case. Coming to Anil Kapoor and Jackie Shroff, now their famous dialogues like Jhakas, and people started using it in a lot of memes unauthorized. They started using at places which needed permission, and they did not take permission. So in today's date, none of us can use it. I'm saying it here because this is fair dealing. I'm just presenting a presentation. Otherwise, none of us are actually allowed to use it in this way. And similarly for Jackie Shroff, like his dialogue of Piru. So even the courts recognize that. Interestingly, so Asha Bhosle's voice, two AI platform actually unauthorized distorted her voice and used it for a couple of songs. So even she could create and get injunction against them. And the most recent one was actually Aishwarya Rai and Abhishek Bachchan together because their images, voices and signatures were used by using AI. So I think it's becoming very serious for them as well, for these personalities. And the law, by setting these precedents, the law is being formed in this space. Coming to another interesting aspects, which is trade secrets. We all think the trade secret for Coke, right? It's a particular taste. It's a trade secret. There is no patent because अगर patent होता तो 20 years बाद वो public domain में आ जाता है and everybody can copy and make Coke at home. But that's a trade secret. And how is that protected? Only 2 people in Coke actually know the process. And it keeps revolving. They have particular agreements in place to be able to protect that. Similarly, when it comes to AI, your trade secrets are important because you have certain algorithms that you don't want to reveal, or you don't want to file copyrights or patents for the same because you don't want it to come in the public domain, which is absolutely fine. It is possible. A lot of companies are doing it. I'm going to set few examples as well, and these are the examples. Coming to like Apple's A series chip remains the best kept secret of Apple Inc. They are the drivers behind the most successful iPhones and iPads. Apple has sued ex-employers in pursuance of keeping them from using the technical expertise developed while using in association with Apple. So how are they protecting this? One, they have to actually sign proper NDAs and agreements. Every company and employee has to do. Because once you get employed with a company, there are certain terms that you need to comply with because there might be certain trade secrets of the company that are revealed during your work tenure. So it is important to have that. There is no codified law for trade secrets, but you have contracts in place. So therefore, these companies like Tesla, Google, Samsung, Apple, all of them have very strong binding agreements which has helped them to actually sue people who have tried to leak any information. And they've been successful in doing all of that. So this is exactly what I was just saying. What you need to make sure your contracts includes for trade secrets, because a lot of tech companies are coming up and they don't want to reveal their algorithms or their source codes. So this is the best way possible. Streaming industry, coming to the closing of this presentation as well. What AI is doing in streaming as well, and I'm going to give you, I'm straight away going to jump to the example of Spotify. So Spotify has bought his big guns against AI, and now they have something called a spam filter. They identify the uploads and block them from being recommended to listeners. They have also brought in stronger enforcement of impersonation violation. So the personality rights that I was talking about, like Asha Bhosle's voice was imitated through AI. So there are these streaming platforms who are trying to get certain regulations in place so that none of this infringement takes place, right?
Actually, I have a question.
Sure, please.
So there are mimicry artists also.
Yes.
So there are would any VIP law applied on them also?
No, so if you're mimicking and there is no defamation, you're mimicking, right? If you're not demeaning the artist, then a defamation case will not have, because the act also has a fair dealing project, right? If I'm giving a presentation or if I'm just entertaining the crowd, there is an aspect under the act wherein it's on fair dealing. But if I cross a line, then it is unacceptable.
What about Samir?
Yeah, so that's another recent case that has happened about Samir and he's... Aapki Adalat, I have that example also somewhere that I actually saved. That Aapki Adalat also is a case that happened here. Rajat Sharma, the renowned journalist, secured protection for his personal show Aapki Adalat. So he has also secured that now none of us can have our show's name as Aapki Adalat.
So if a mimicry artist is trying to record any song in the voice of any renowned artist, so how would they be get to?
You cannot so that's where the lining comes, that I cannot pretend to be somebody else and sing the song.
So what is in the case of the similarity of voice? So there are humans, there are twins in the form of face, or there are voice twinning too. So how the Spotify would be able to eradicate?
So Spotify, exactly what Spotify has done, because a lot of complaints went to these streaming platforms and they have tried to actually check. So what happens with Spotify, if I have a song and I'm registered with Spotify as an artist, I upload my song, right? Or that's how the equation works. So they have this spam filter. Why they are saying spam filter? Even on Instagram, if you see, if they make a fake profile of mine, I tell all my friends to report this as spam, spam, spam. Or so it goes to the spam filter, and the profile is taken down. Similarly, Spotify is doing that. If I, as an artist, recognize that anybody is imitating my voice and my songs, I can quickly report it, and they'll put it to the spam filter, and nobody else can download it. So that's how the algorithms are working now. It's not anymore easy to copy these personalities as well.
But my question is something different. I was saying that there is an artist said as Nusrat Fateh Ali Khan. He's not alive. So somebody has been trained to voice like him and sing like him. So there is a company who has already the rights for the Nusrat Fateh Ali Khan. But now the new artist is coming, try to mimic the Kishore Kumar or Nusrat Fateh Ali Khan. So it is all human doing his own effort. So how the platforms are not violating their rights of the artist who are trying to put their own effort in that?
There's no, if I'm trying to mimic it, that's what I'm trying to address here, that if you're trying to copy any such renowned artist, their voice and their work actually, after, even if they pass away, belongs to their legal heirs under the Act. So I cannot do that. I'm not allowed to do that unless and until a company, suppose their songs are bought by T-Series or Saregama, but their songs will be played originally. If I want their song to be played in any upcoming movie or remixed, I'll have to take permission from their and their legal heirs. So what you're saying, that you're not allowed to do what you're trying to say. Nobody is allowed to do that. Yeah. So ending my slides with certain legal do's and don'ts. User business should ask the AI service product provider to confirm if AI is under trade secret protection and ensure that appropriate steps be taken to preserve ownership of IP rights. So this is again very important. Clarity should be sought whether the AI output is owned by the user business. So a very important aspect, whatever business is generated, if you're using any source code, anything, it is important to ensure that the output, you have the IP in that. Or the user, you should know so that you can convey it to your consumers. Seek clarification as to what extent the AI algorithm comes from third party or open source software. Confirm if the input or output of the user data shall be used to train AI models. To minimize the risk of any inadvertent infringement, details on the data, source thereof, and training of the AI product service should be sought. सो वेरी इंपॉर्टेंट कि वो किसी थर्ड पार्टी का डेटा तो नहीं इन्फ्रिंज कर रहे हैं और आपको बोल रहे हैं आप अपना बिजनेस हमारे प्लेटफॉर्म पे बना लो. So this is also very important to check. Carefully review the definition of AI data. So these are the definitions that you need to see: the duration, the scope, indemnity, confidentiality, IP clauses. In addition to licenses secured in contracts, the user businesses must review the policy. That I was saying, that I agree that we do. We need to review, especially using such AI models, and checking for biases in training the AI, ascertaining transparency and accountability, and ensuring that no ethical concerns are there to any malicious activities. So these are certain legal do's and don'ts that I wanted to end this presentation on. So thank you for being a very patient audience.
One small question: where can we delve deeper into the matter? I have a loud voice, like.
Yeah. Delve deeper into the matter.
Into the matter. For an example, I want to create a social media platform, and for that sake, in order to protect myself, because I'll be investing a lot. So, where can I go deeper, study it? I should not be copy this reels idea, post idea, but Instagram does not put any case on me.
So Instagram also has certain terms of use that needs to be complied. So that's why what Jitin was also saying here was it's very important कि आप Google से तो आप पूछ ही लेते हो.
In addition to seeking Talwar's services,
anyway,
what else I can do on my own? In addition to where I can go, what is the right relevant source of information? Where I can understand more, what to do, what not.
So the acts are there in place.
Exactly.
Other than that, on AI, I think Jitin sir will be able to tell you better that where you need to seek this knowledge from, because there are a lot of research on this pattern and he's read through everything.
Let's shoot. Tell us what is it. Let's take you to a particular. Let's take you to a particular direction. Tell us what is it.
Okay. So I want to create a social media platform, which would be a blend of Instagram, Facebook, TikTok, and I will be, obviously using their what they are doing, like they are using this reels, posts, stories, some of their, trending things into my system. So how to protect myself?
So go to a doctor and tell him I have a headache. Sometimes the headache gets bad, etc. Because these are very complex things, right?
Correct.
So you have to, again, these are not small ideas. These are billion-dollar ideas. First of all, there are licensing aspects involved here. There are personality rights involved here. There are AI rights involved here. So you can't. That's why the barrier to entry to these Facebooks and Instagrams are so high, and you just can't do that. There are AI rights, there are copyrights, there's technology, there is servers, there's liabilities, there's data protection, there's everything. It's basically combining all these 32 things into one. You can't do that, right?
On my own.
It's very easy. I mean, it's not easy. It's very complex. It's like I want to. No, even us. Like it's not about that. It's just about. That's exactly the same thing, right? Some kid on the block can't just start tomorrow onwards. I'll be starting on Google of my own. They take years to build. Even Instagram took 10, 12 years to perfect their business model, and billions of dollars, literally. So it takes time. These are not. So start one step at a time, and then build it up. Sorry, no easy answers. So I always say you can't solve something through a iris scan, something that needs an MRI. Scans that are needed.
Something smaller could be done, but
you can't call a doctor and say, "मेरे को सिर दर्द हो रहा है, दवाई दे दो."
Thank you.
Thank you.
Does anybody have any questions? No? So thank you so much to our speakers for this very informative, lovely session. Thank you. And I would like to now invite Mr. Gaurav Vats to kindly honor Mr. Jitin Talwar. So just a small token of our appreciation. next I would like to invite Mr. Abhishek Sood to kindly honor Ms. Pritika with a token of our appreciation. Thank you so much. As we reach the end of such an incredible day at TiECON 2026, let's take a moment to reflect on our journey so far that we have undertaken today. As we, from networking with intent to understanding data protection, exploring team culture, celebrating tier 2 innovation, learning about global growth, hearing local success stories, and finally discussing AI, intellectual property, and the future of innovation. All these sessions have truly taught us how to be better at what we do. With this, there's a key takeaway that we should dream boldly, build fearlessly, and never take the entrepreneurial journey alone. Thank you for being a part of TiECON 2026. This is Sukmani Kang, your MC for today, signing off with gratitude and excitement for the journeys that will begin after today. Until we meet again in the next TiECON, keep innovating, keep building, and keep believing. Have a wonderful evening ahead. Thank you so much for thank you. I would like to invite everybody for a group photograph to close the session.
Sir, please.
Thank you. Thank you so much.
Thank you for your efforts.
Thank you so much. Thank you. It was fun being an MC today. This is the last session here for today. Thank you so much. Thank you so much. Thank you. It was lovely to meet you, and we should keep meeting. Let's catch up over a coffee or a matcha or something. Okay. Thank you, ma'am. And please be connected. After